Hi everyone, today we're going to talk about torts. This class is Module 1, Topic 2. We'll focus on intentional harm and defenses. Introduction. So in this lecture, we're going to talk about the high-frequency testable zones of torts exam. So there are several very typical topics we're going to address. The first one, intentional infliction of emotional distress. That is IIED. Second, trespass to land. Third, trespass to chattel and conversion. The last one, we're going to talk about the defenses to intentional torts. So we can use the synchronym, acronym, POPCANs: privilege, defense of others, defense of property, consent, authority, necessity, and self-defense. Okay, let's dive into the IIED. So IIED is the plaintiff can sue the defendant for damages if there's some outrageous and extreme conduct to cause the psychological damages. It doesn't need to be physical. So there are several elements can compose the IIED. The defendant must demonstrate intentional or reckless conduct, and that conduct must be extreme and outrageous, which causes severe emotional distress. So that those are the elements for an IIED claim. So the breakdown for IIED will be also very straightforward. The first one, intent and recklessness. So the plaintiff must demonstrate that the defendant either has the intention to cause the result, or recklessness, which means deliberate disregard of a high probability. The defendant knows the conduct or the result must happen, but just ignore it and disregard it. The second one will be the extreme and outrageous. It cannot be a simple result. It must be beyond the decency, a very severe decency and inconvenience. So this one will base on the reasonableness. So we will see whether a reasonable person can tolerate. So to avoid extreme sensitive people. The third element is severe distress. It must be more than a reasonable person's expectation. So in reality, the plaintiff might need to demonstrate the police record and some real disease to be eligible. And then the last one is we need to keep in mind, because this one is an emotional side, so intentional or reckless emotional damage, so it doesn't require the physical injury. A very interesting thing when we are discussing the IIED will be the gatekeeper. So we do set a bar for claiming IIED, because IIED is kind of like an intangible, so it is hard to see from the surface. So we set a higher bar. So the first one will be the judge or the court will be the first screener to screen out the extreme and outrageous. But after the screening, so if we still have the difference of the definition of outrageous and extreme, so we leave it to the jury. The jury will use their discretion to decide whether this case will be considered extreme or outrageous. So that's the second screen. And we do have a third-party IIED. So that means the plaintiff does not have to be a victim, the direct victim. It could be the third party, but it requires more than the regular IIED. So first of all the elements must be met. The elements we mentioned must be met. The second, the victim must be an immediate family member of the emotional distress. of the result. And also it must be present and or known to be present by the defendant. Similar with the IIED, it doesn't require bodily harm. However, if it is for any other person, maybe that person does not have any relationship with the original victim, and it requires bodily harm. So that is the third party IIED. So the second very testable topic of tort law is the trespass to land. Later on, we'll talk about a very typical case, Martin v. Reynolds Metals. So the trespass to land means the defendant has done the intentional act, causing a physical invasion of the plaintiff's land. So we can see that the breakdown of these, the rule is the first one, intent. So the defendant must demonstrate the intention to move in to the land by herself or some particles belonging to him. Keep in mind here, mistake is not a defense for the trespass to land. You cannot say, oh, I'm sorry, I didn't recognize that the land does not belong to me. So I invaded it, I entered it mistakenly. So it is not a defense. The second one will require physical invasion. So before physical invasion does not include some super tiny items, and such as the smoke or some other elements. But the modern science can prove that even the smoke is some particles inside, has some particle inside. So, and then the modern rule allow any size of particles or like some smoke, smell, or even energy can be considered as the physical invasion. So if the particles or the items physically enter or settle into the plaintiff's land, that will be considered as invasion and trespass to land. And the third element is actual damage is not required. The plaintiff does not need to demonstrate to suffer some loss. That's the reason sometimes the nominal damages will be available for the trespass to land claim. And then the last element is, when we're saying that invasion, it doesn't have to be to invade the surface of the land. It could be the airspace or the subsurface, as long as the owner or the plaintiff usually can benefit from them. So when we are using the trespass to land to study hypo or doing the essay spot question, several points we need to identify. The first one, trespass to land is violating the possessory interest, the owner's possessory interest. And most of the cases, nuisance and trespass to land happen hand in hand. The only difference is trespass to land is to violate the possessory interest, and the nuisance is to violate the owner's use and enjoyment. So they always come together like two sisters. The only difference is when we are having we do have a strict liability of the trespass to land if the action is with highly danger or risk. And then the last one we need to be cautious is the different statute of limitations. That's the origin of the Martin versus Reynolds, and depending on what the action the cause of action is, and we have different statute of limitations. Trespass to land has longer statute of limitation, and nuisance has less statute of limitation. Okay, after we discuss the trespass to land, now we're going to talk about the trespass to chattel and conversion. The previous one is regarding the real property, and this one is regarding personal property. So let's take a look at what trespass to chattel is. Trespass to chattel, it is an intentional interference with P's personal property, and also the interference causes harm. Several elements, we usually analyze a rule. So the first one, dispossession. The defendant takes or withholds the item away, or intermeddling. That will be damaging or impairing the item. Also here, the actual damages are required. So the defendant must cause some actual damages. If there's no damages, and the claim cannot be proceeded. And then the last one is mistake is not a defense. You cannot say, oh, I didn't know it is not my item, so and then I just take it mistakenly. So that doesn't count. The second one is conversion. Conversion is very similar with trespass to chattel. Usually they happen hand in hand together. So when there is a trespass to chattel, usually the plaintiff is also suing conversion. The factors of conversion includes intentional dominial or control of the item, and the main difference is that of the conversion has the seriously substantially interference and cause severe harm. So the main difference is the condition of the item, the level of harm. If the harm is very severe, so you can call it conversion, because you cannot just compensate the difference and then to satisfy the plaintiff. Usually the remedy requires the entire fair market value. Or you can return the item, but you have to also cover the detention damages. There's a very popular case, Tyroff. So it is the electronic data. Before, electronic data was not considered as personal property, but the current, the modern approach consider electronic data also is real personal property. So that also counts as conversion. There are some examples to help you understand trespass to chattel and conversion better. The first case, your friend takes your jacket overnight, and after return it, and there's some stain on the jacket. So that will be the trespass to chattel, and loss is the stain on the jacket. So your friend might be liable for to clean the jacket for you. And another hypo is your friend borrows your car, but instead of returning it, your friend sold it, and that will be considered as conversion, because that will be the entire loss of the value of your car. So most likely your friend need to compensate you the fair market value of the car. So after we talk about IIED, trespass to land, trespass to chattel, and conversion, now we're going to talk about some defenses for the previous torts activities. We summarize them into the pop cans. They are very common defenses to the tort law, tort disputes. The first one, when we're saying the defenses, that will be the defendant's obligation or burden to provide the evidence, or also the scope of reasonableness, controls, liability, and damages. So the first one, privilege. So privilege means the action is permitted by law. For example, the defendant entered the plaintiff's land because the plaintiff's ranch is on fire. The defendant just want to go there to stop the fire. So is it a trespass to land? Yes, it is trespassing to land, but the defendant might have a very good excuse, a defense for that. It is called privilege. because it is permitted by law. The second defense is consent. Consent means mutual agreement. I allowed you to do this. And there are some elements of consent. The first one, consent could be expressed or implied or by law. The second one is the scope matters. If the consent has limitation, but if your action exceeds the limitation, that's not a good defense. The third one is split on legal mutual combat. There is a split, a disagreement between different jurisdictions. What if that is an illegal combat? Both parties agree with each other, will be not liable for any damages, but some people, one of them either dies or suffers a severe injury. So how does the defendant have a defense? So the court split here. So some jurisdictions say yes, because they have mutual consent, but some jurisdictions disagree. They think that both parties are still liable for each other's damages. The last example is the sports. When people playing sports, they have the implied consent, but only for the ordinary play. But if someone in the sport, in the game, does some excessive violence, and that is not a defense. Next one, the defense is self-defense. A very typical case will be the Courvoisier and Raymond case. When you're using the self-defense as the defense, the defendant must demonstrate. The first one, the reasonable belief. The defendant reasonably believe there's an imminent harm to himself or herself, and then the harm is unlawful. The second element is proportional force. If the upcoming imminent harm is deadly, so you can use deadly force to respond, but you cannot use deadly force for non-deadly imminent harm, imminent threat. So your defense, your action must be proportional to the expected imminent harm. The third is no duty to retreat. You don't have to retreat. You can, if you think that your reaction is proportional, so you can just do it without retreating. And then next element is mistaken self-defense can succeed if the mistake was reasonable. If you mistakenly thought the other is going to hurt you, and you can still use it as a defense, as long as your prediction, your expectation is reasonable. And then the last one is the limits. We do have some limits for the self-defense. The first one, you cannot use this defense against privileged actors. For example, the police arrest you. They are duly authorized person to arrest you. You cannot say, oh, I think that there is an imminent harm coming to me, so I'm going to counter back. So that is not a defense. The next one, O is for defense of others. Very similar with the self-defense. The defendant must demonstrate reasonable mistake, and also the reaction is necessary and proportional. And D is for defense of property. The defense of property must be reasonable, but not deadly force to prevent intrusion. There's a very typical case between Catco and Briney. Briney set up a spring gun trap, and to set a gun toward the door. If some intruder enter the door, the spring gun will shoot, and then will shoot the intruder's leg. So that system is deadly. The intruder's act is not deadly, so you cannot use the deadly force to protect your personal property. And N is for necessity. That will be also a very typical case of Vincent versus Lake Erie transportation. Keep in mind public necessity if you are doing this action for public purpose, and the result hurts someone's, cause someone's loss or damages, and that is complete privilege. So you don't need to compensate the plaintiff. And if that's for private necessity, like this case, Vincent versus Lake Erie Transportation. So the boat was tied in the dock, and because of the storm, so the boat cannot leave the dock that night. So and then the boat damages the port, and it is a private necessity because we know, so in the storm night we are not supposed to leave the dock, so for everyone's safety. But yes, that is okay, but you have to compensate the owner's loss. And last one, the reasonable mistake about necessity is okay if objectively reasonable. Okay, so the mistake it can be considered as the defense here. The last one is A. A is for authority. Like we previously mentioned that arrest under warrant, so that's under authority. You can the person can use it as a defense. And the shopkeeper's privilege, if the shopkeeper has the reasonable suspicion, reasonable manner, reasonable time, and they can keep a person for during the reasonable time. And then the last one is the parental discipline for parents. If parents use reasonable force, considering the plaintiff's age, conduct, and motive, that's also allowed as a defense. Okay, there are several hypos. Lastly, we're going to apply the rules we mentioned previously to do some analysis. A very quick one. The first one, there's an undercover private detector lies to get your photo. Repeated police contact follows and panic attacks miss work. So can it be considered as IIED? My answer for this one is it depends. Depends on the outrages and severity. And keep in mind, the judge will have the first screen to decide whether the conduct is outrageous. And second, the jury will have the second strike. So the plaintiff need to pass 2 screens in order to claim IIED. So that's not very easy, not very straightforward. So that's the reason I'm saying that depends. The second one is factory emits fluoride dust that settles on ranch. Cattle get sick. So this one could be either trespass to land or nuisance, depending on which one will best suitable for the plaintiff, depending on the statute of limitations. So the fluoride dust can be considered as the element or the particles for the trespass to land. That's okay because the modern science have proved that very tiny particles exist, and that usually it's okay to consider as trespass to land. The third scenario is the friend takes your laptop for the night. You miss the deadline, returns it intact. This one is likely to be trespass to chattel, because your friend takes your laptop and you suffer some damages because you missed the deadline. So your friend is liable for compensate you for the loss or damages. Next one will be the storm forces ship to stay tied to private dock. Dock breaks. So this one, there can be a defense, but the defense is for private necessity. That means you're doing this for protecting your private property, not for the public. So therefore, it is a defense, but you are supposed to compensate the plaintiff or the owners of the dock's loss. The last one, the shop detains customer for suspected theft for 90 minutes. And that is also considered as a defense, as long as all the actions are reasonable. Reasonable time, reasonable motive, and reasonable manner. So lastly, we're going to summarize what we are learning in this lecture. The first one, we talk about IIED. The IIED must contain the intentional reckless, plus extreme and outrageous, plus severe distress. Judge will have the first screen, and jury will have the second call. Trespass to land. The defendant must have the intention. There must be a physical invasion. It could be the the defendant himself, or some particles, but no damages are needed. Trespass to chattel. The defendant intentionally interfere with the personal property and cause some harm. Conversion. Similar with trespass to chattel, there must be intention, seriously dominant control, and if that happens, either the defendant compensate the fair market value or return the item with the damages. The modern law includes electronic data as personal property. Lastly, we talk about defenses. We can use the acronym POPCANs to capture all the elements. Usually, the defendant has the burden, and we need to apply them carefully. That's all for today's lecture for the different types of torts, laws, and defenses. I hope you like this lecture. I will see you in the next class.